case of State of Ohio versus Quinn White. Mr. Murphy arguing on behalf of the State of Ohio. Attorney Stepanek waived argument, so you'll be the only argument we'll hear on this case. You'll have 15 minutes to present your argument. We've read the briefs and are ready to proceed if you are, sir.
Yes, Judge, good morning. Brian Murphy, Assistant Prosecuting Attorney. First time I've said that since I started here. Lorain County Prosecutor's Office. I was always wondering when I was finally going to say that.
It was inevitable, right?
I still go to our old courthouse.
Yes, she does.
Judges, I don't mean to waste any of your time on this issue. I'll be very brief. The state just wishes to point out that in this matter, Quinn White entered a plea of guilty to these charges. In doing so, he waived appellate right. I should say, a vast majority of his appellate rights in force. He did so with counsel, who in fact is also appellate counsel here. And by pleading guilty, not no contest, he did not plead no contest, he pleaded guilty. He waived the right to appeal that trial court decision to deny the motion for intervention in lieu of conviction. The state just wishes to point out there is no argument in appellant's brief that the plea was not made knowingly, voluntarily, and intelligently. The state recognizes that if that argument were made, that would constitute grounds, assuming that the argument could be fleshed out, for appealing, would be viable grounds for an appeal, but that's not the argument. So presuming, or knowing that it was a voluntary and intelligent plea, all non-jurisdictional defects are waived. And there's no argument set forth here by Mr. White, by appellant counsel, as to why this rule that's well established should not apply. I know it's really a basic argument, it seems, but I want to make sure that the court doesn't have any other questions regarding this matter.
The only thing I was wondering is, obviously his argument is the whole thing, he wants intervention in lieu of conviction.
Correct.
And we haven't, at least I haven't read the transcript of the sentencing, so obviously I will. I guess what I'm wondering is, it sounded like that was still on the table and the judge just had to decide.
Correct. The state acknowledges that procedurally this case was a bit unusual in that Mr. White came in and entered a guilty plea that was held in abeyance, and then either it was kind of set for a joint sentencing hearing where we'll jointly address your motion for intervention in lieu of conviction. To me, that's an issue for defense counsel to have addressed at that time, which was either insist upon the trial court ruling on the motion for intervention in lieu of conviction before his client entered the guilty plea, or asking to withdraw the guilty plea when the judge said, well, I'm not going to grant it. And I think there probably would have been, under the rule for withdrawing guilty pleas, there's probably good grounds for doing so, especially freely granted.
Was there anything in the record that indicated they agreed to intervention in lieu of conviction at the time they entered the plea guilty and the court did not follow the agreement?
No.
They just agreed to have him screened. Or I don't know that the state agreed to anything. The court agreed to have him.
The court agreed. I think the court allowed him to go through that process, and withdrawn the guilty plea and maybe then at that point entered a no contest plea, or just revisited his options at that point. But once the trial court denied that motion, and I would point out, again, procedurally, there's kind of a technicality here where I just want to make sure, from the state's point of view, that guilty plea is not technically entered officially until the trial court, of course, journalizes it. So the motion the motion for intervention in lieu of conviction is denied prior to the guilty plea being formally entered. Despite his saying guilty, it's being held in abeyance. Then the court says, I'm going to deny your motion, and then there's the finding of guilt there. So just because that case law, the case law says that any pre-trial motions before the guilty finding is entered, that guilty finding breaks that the chain in the procedure of the case. So it looks like maybe the motion might have been denied after the guilty. From the state's perspective, hyper technically it was not. It was denied, and then the finding of guilt's made, which means that the motion's denied prior to the guilty plea being officially
Because you
entered.
journalized it afterwards.
Correct.
Either way, they didn't ask to withdraw the plea.
No, Judge.
And he couldn't have entered a no contest plea, right?
Absolutely.
No, I said he could not have, to be eligible for,
You know what, Judge, having read this statute a number of times, I don't know why he,
probably the prosecutor's office won't allow you.
there'd be that argument, as to whether the prosecutor's office would, but the problem, thinking aloud, is if the defendant's pleading guilty to the indictment, or I'm sorry, no contest, as charged, and is otherwise eligible upon a finding of guilty, I don't know why he couldn't.
Well, probably for the same reason you're talking about, so that you can preserve all these.
What I'm saying is, I don't know why he couldn't plead no contest. I could understand if the prosecutor's office is saying, well, we'll reduce a charge to allow you into the program, but you have to plead guilty. But here he was pleading to exactly as charged. The prosecutor's office really doesn't have any, and I don't know that I had a reason necessarily, obviously to object, but to keep him from pleading no contest in the trial court, pleading in.
What about the fact that the court said, other than discussions involving intervention in lieu, were there any other promises made to you?
Yeah,
And the defendant says, no, sir.
I think the only discussions about intervention in lieu, I think what the trial court is referring to in the greater context is, we've discussed intervention in lieu of conviction, we'll address that at the next sentencing hearing on February 7th, I believe was the date. I think that's the only promise or discussion. We'll address the motion at that point.
And no, the court did not tell him, I'm not saying anything about the attorney, but nobody talked to him or told him on the record that you won't be able to appeal this if I deny your intervention.
Specifically, I don't believe that assertion was made.
Anything else, Judge Kelly?
Yes, sir.
All right, thank you, Mr. Murphy,
Thank
for
you.
your argument. We'll take the matter under advisement, issue a decision in due course, and the clerk will mail you a copy of the court's decision on the day it's released.